We need to talk about the Supreme Court and porn. Right, in that, because during oral arguments in a case yesterday, the High Court justices signaled that they are likely to uphold a Texas law requiring age verification for porn sites. A move that many say would roll back not only First Amendment protections for porn, but potentially even open the door to broad restrictions on online speech. Because specifically, the law in question requires people to verify their identity and prove that they are over 18 in order to access any website where more than a third of the content is deemed what they call sexual material harmful to minors. With that law then also mandating the sites post a warning that porn is potentially biologically addictive and proven to harm brain development, which is also a claim that's been widely disputed by experts. Now, also notably here, Texas is just one of the nearly 20 states that have imposed these kinds of age-gating laws. And as we've talked about before on the show a handful of times, those laws have then resulted in Pornhub suspending service in almost all those states, which has essentially made one of the world's most popular and well-known adult sites unavailable across a wide chunk of the South. But in Texas, Pornhub and other adult industry groups sued, claiming that the law violated the First Amendment and the identity verification requirements raise very serious security and privacy concerns, with them arguing that users' identifying information could be hacked, sold, or otherwise misused, thus opening them up to identity theft or possible extortion. And this, as the adult content groups noted that the law has a major loophole that would prevent it from being effective, saying it doesn't restrict access to porn on social media or other sites where less than a third of the content is sexual material. And saying at the same time, the law leaves this, we'll call it a gaping hole, because it also restricts access to other sites that are mostly devoted to content that isn't sexual. And initially, what we saw is that a federal court in Texas agreed with those arguments, striking the law down. But the state then appealed, and the conservative Fifth Circuit Court of Appeals reversed the decision, allowing the law to go into effect. Though there, it did strike down the warning label requirements. And in their decision, the appeals court justices cited a 1968 Supreme Court ruling that upheld a law making it a crime to sell pornographic magazines to minors. But then, of course, the adult industry groups appealed to the Supreme Court. And in oral arguments yesterday, lawyers for the plaintiffs argued that the appeals court had erred in its decision, noting that there was a much more recent, much more applicable Supreme Court ruling that could be applied. Because back in 2004, the High Court struck down a similar federal law that aimed to protect children from online porn, ruling then that states can restrict minors' access to sexual content, but any laws that might limit adults' rights to free speech need to undergo the most rigorous legal standard called strict scrutiny. Which I will say, to not get too deep into legal jargon, all you really need to know is that the strict scrutiny standard, it basically says that the government needs to have a very, very good reason for passing a law that may infringe on a constitutional right, like, for example, the protection of public health and safety. And even then, the law also must be designed to advance that public interest in the least restrictive way possible. And if that sounds like an almost impossibly high bar, it's because it is. Most laws do not pass the strict scrutiny test. And so in the 2004 Supreme Court ruling, the justices applied that standard and said that the federal law violated the First Amendment, arguing that there was a less restrictive way to limit minors' access to porn. With them writing at the time, instead of requiring every porn website to verify the age of every user, the government could have just promoted content blocking or filtering software. But that was a major departure from the 1968 ruling, which used the most lax legal standard, rational basis review, which just says that a law needs to have a legitimate purpose. So, like, almost all laws. Or, as the Washington Post explained, in other words, Texas is claiming that the situation today more closely resembles that of 1968, when it was assumed that human shopkeepers could distinguish kids from grown-ups at a glance. And so in their arguments before the Supreme Court yesterday, lawyers for Pornhub argued that the 2004 decision and the strict scrutiny legal standard it relied on should be applied in this case as well. With them saying, like in that case, there is a less restrictive alternative to age-gating all porn websites, specifically then pointing to the same alternative the justices flagged back then, teaching parents to protect their children by using content filtering software. But that then drew objections from several justices, including Amy Coney Barrett, who referenced her own 7 children.
Kids can get online porn through gaming systems, tablets, phones, computers. Let me just say that content filtering for all those different devices, I can say from personal experience, is difficult to keep up with.
You also then had Samuel Alito chiming in.
Do you know a lot of parents who are more tech savvy than their 15-year-old children?
There's a huge volume of evidence that filtering doesn't work.
Though here, I will say my favorite thing that came from Alito was him asking about the content on Pornhub.
What percentage of the material on that is not obscene as to children?
Well, Your Honor, if we're talking about the youngest minors, I would agree that most of it is, and that is how we read the law.
Is it like the old Playboy magazine? You have essays there by the modern-day equivalent of Gore Vidal and William F. Buckley Jr.?
Not in that sense, but in the sense you have sexual wellness posts about women recovering from hysterectomies and how they can enjoy sex. That's on there. Discussions of age verification proposals and where the industry lines up as far as what they think should be legislated and what should not.
But then beyond all that, we saw a number of justices seemingly favoring a point made by lawyers representing Texas who argued that so much has changed since 2004 that has made porn so much more accessible and prolific, thus requiring more government intervention, with several justices justices making it clear that they believe that the rules that govern online porn must be flexible enough to allow some laws that try to block children. And there, I will say it wasn't just conservative justices who made that point. We also saw that echoed by Justice Kagan.
It's just got to be the case that states can do some regulation in this area.
Right, and so then, with all this, the question isn't whether or not the Supreme Court is going to block this law, but rather how broad their ruling is going to be when they decide to uphold the law. And the crux of this question is going to come down to what the justices decide regarding which legal standard to apply when regulating online porn. Will they go with the strict scrutiny standard they used in the 2004 case, or will they go with a more lax standard like the Fifth Circuit did in its ruling? And a big thing there is you have experts saying that if they do use that more lax standard, it could have a sweeping impact that goes way beyond just porn and undermines free speech across the internet. With us also seeing free speech advocates here saying that this is just a part of the conservative attempt to crack down on free speech and could pave the way for restrictions on content related to gender identity and reproductive health. Or as one expert wrote in Vox, another question is, if the court permits age gating, what sort of content will the court allow the government to place a gate around? Could the state of Florida forbid children from reading a transgender author's memoir of their transition? Or could it similarly prevent gay teenagers from accessing online forums where queer people discuss their sexuality? But for now, we're gonna have to wait to see what the court decides. Hey, thanks for watching, and I hope you enjoyed this clip from the full Philip DeFranco show. And also, a big thanks to Squarespace for sponsoring our Clips channel. Turn your passion into profit over at squarespace.com/Phil, or use the QR code. Because whether you're launching a business or a lucrative side hustle, your website is your digital business card. It's the only space where you control the story, no algorithms or distractions. And with Squarespace, it's so easy because they got a ton of stunning professional templates with drag and drop editing that makes site design incredibly simple, no coding required. So get started for free at squarespace.com/Phil, or scan the QR code on screen and use code Phil for 10% off when ready to launch. Squarespace.com/Phil.